What can Americans do if the government retaliates against them for speaking out? I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely. And today we're going to discuss real-world examples of government retaliating against citizens for speech it doesn't approve of. We're joined by IJ attorneys Kirby Thomas West and Ben Fields. This is Beyond the Brief. And the first case that I want to talk with you guys about today is Waylon Bailey. Can you kind of explain what's going on with Waylon?
Sure. So Waylon Bailey is a boxer who lives in central Louisiana in Rapides Parish. And at the beginning of the pandemic in March 2020, he, like most people, was at home. He's actually setting up a home gym in his garage. And he made a joke on Facebook. Like many other people, he was comparing it to a zombie apocalypse. And he made this joke saying that, painting a picture of the local sheriff's office treating it like a zombie apocalypse and hunting the infected. But it was over the top. It ended with a hashtag "We need you, Brad Pitt," in reference to Brad Pitt's zombie movie World War Z. Had all sorts of emojis. It was just shared among friends. And for the first few hours, it was just what it was supposed to be. Friends were bantering about it in the comments. But it turns out that the Rapides Parish Sheriff's Office had seen it and didn't like being the butt of a joke. And so without any sort of investigation or anything, they pulled together a SWAT team, rushed to Waylon's house, and with guns drawn, multiple officers in tactical gear arrested him and said that the post was terrorism and charged him under a terrorizing statute. He had to spend several hours in jail until his wife could bail him out. And then his face was just plastered all over local news, accusing him of being a terrorist. And so, as you can imagine, this was ridiculous. The district attorney refused to prosecute the charges. And so Waylon then sued the sheriff's office officials who had targeted him for this joke on Facebook. And unfortunately for him, he ran into the buzzsaw of qualified immunity in the district court. And what the court held was, by applying law from the Wilson administration in World War I, when the government was rounding up people who criticized the government's war policies and throwing people in jail for distributing pamphlets, the Supreme Court had upheld those kinds of jailings, saying that it was a clear and present danger to, for instance, distribute socialist pamphlets. And that's actually where the shouting fire in a crowded theater comes from. That case had nothing to do with theaters or fires or shouting at all. It was a guy distributing pamphlets that the government didn't like, and they were allowed to throw him in jail for that. Fortunately, the Supreme Court in the decades since has said that's no longer the law. And by the 60s, it was quite clear that that category of speech, incitement, that falls outside the First Amendment, was a much, much narrower standard. But even so, the district court said, I'm going to apply this World War I era law and throw this out of court. That's when IJ came in. We saw that this was absolutely absurd. So first of all, as you said, it was just very, very troubling that somebody could post a joke that made fun of a local government official and then end up being charged with terrorism as a result. But it was also very troubling from a First Amendment perspective, because if this World War I era case was going to be brought back, then everybody who sounds off on social media was susceptible to being thrown in jail. And so we took the case over on appeal, brought it to the Fifth Circuit, successfully argued that that was a ridiculous application of the First Amendment. The Fifth Circuit reversed in a very strong opinion, making clear that Waylon's speech was protected under the First Amendment, and that the stretching this Louisiana statute to reach that speech also violated the Fourth Amendment, because no reasonable officer could look at that joke and think, oh, this is terrorism, and therefore I have probable cause to arrest somebody. And that's exactly what retaliation is. It's when officials, they see there's actually a Soviet, the first head of what became the KGB, Laurent Beria was his name. He has this famous aphorism, show me the man and I'll show you the crime. And that's sort of what retaliation is. The government sees, well, they don't like this person. And then, there are always hundreds or thousands of local and state laws that you can look to figure out what it is. Here they happen to pick out a terrorism statute that obviously didn't apply. And that's how it works. Unfortunately, the Fifth Circuit said, no, we're not going to let that happen. And within 2 months of the Fifth Circuit sending the case back to the district court, Whalen got to go before a jury of his peers. They agreed this is unconstitutional, and they awarded him $205,000 in damages for the unconstitutional conduct of the sheriff's office.
So hearing that, I have a few questions off the bat. And the first is, how did the district court get this so wrong? I mean, not only did they apply World War I era precedent to this case, which, as you just described, has been overruled now for nearly 60 years, but in addition, how did they try to put his joke in the context of pamphlets that were protesting the draft? I mean, they seem like such different issues. And how did the district court at all bring what Whalen did into the ambit of these sorts of very particularized cases?
Yeah, so I think that this is sort of, this is how qualified immunity often works, that there wasn't really that level of analysis that you're suggesting. Instead, the vast majority of what the district court did is conduct its own research and show, March 2020 was generally a stressful time, which nobody disputes. Obviously it was. We all lived through it. And so he said, well, it was stressful, so I'm kind of going to throw up my hands and just give the officers the benefit of the doubt. No matter how absurd it is that they stretch this statute, it was generally stressful, so they could have thought that this was some sort of speech that could be proscribed, and so I'm just going to let it go. And I think he sort of turned to these World War I cases as a hook. But I think it was really driven by that intuition rather than being driven by the law, which unfortunately is sort of what qualified immunity often asks courts to do.
Right. Well, one of my favorite things when this case reached the Fifth Circuit was during oral argument, when I think one of the judges on the panel asked opposing counsel, did the sheriff know who Brad Pitt was? Because as you mentioned, right, the joke very prominently says, #we need Brad Pitt. And at argument, the judge tried to ask opposing counsel about that, right?
Yeah, so one of the judges asked, to make the point that you're making, that obviously this is a joke. And our opposing counsel said, well, he's just a simple country boy. He doesn't know who Brad Pitt was. And the Judge Douglas, I think it was, she latched onto this. It's like, you're seriously telling me that your client doesn't know who Brad Pitt is? And he said, well, he doesn't know him personally. And one of our colleagues after the argument said to me, well, I feel like, I know who he is, but I don't know him personally. That's also my relationship with Brad Pitt.
So are authorities usually this, extreme about it, right? Like this, terrorism statute, that seems completely outlandish. Like normally this kind of thing, when you think of people are, being charged with a crime for, in retaliation, it's for something like jaywalking or, whatever, some like simple, obvious law. They're not kind of making this strange leap to, you're a terrorist actually for Facebook jokes. So what does kind of the simpler version of this even look like?
I mean, I think that it runs the gamut. As we were talking about, there are just so many laws on the books. They're famously, like, there are books saying that, like, everybody commits 3 felonies a day because there just so many things are criminalized. Statutes are written so broadly that, sure, one way that you can target people who you don't like are to go after these endemic crimes like jaywalking or parking violations that people don't even know are parking violations. So that's certainly one way to do it. And we've seen cases like that. In fact, I'm currently representing somebody in a city in Ohio who was targeted for campaigning against his mayor with a parking ordinance that literally had never been enforced to anybody in remotely similar circumstances. But there's the other category where there's just laws that are written incredibly broadly. And that is sort of where the terrorism statute came in, that officers, the statute on its face is written very broadly. Courts have interpreted it much more narrowly to comport with the First Amendment, but officers will just reach for whatever is available. And often it isn't police officers who are doing this. It isn't even people who necessarily know about the law. It's often mayors or the law department, or other officials who are just leafing through whatever ordinance or statute comes to mind that they can weaponize against their opponents.
What did this case mean to Whalen? He's been fighting this now for years. He just got this phenomenal jury award in this case. Without IJ, odds are an attorney probably wouldn't continue to litigate that case on appeal, perhaps because it would have been too costly or the contingency fee might not have been worth it. So how did Wayland react, not just to the Fifth Circuit reversal, but his subsequent victory at trial?
I mean, this was huge to him. As I said, he was tarnished in his entire community as being a terrorist. That's sort of the last that anybody heard of it. In fact, the sheriff's office went on their Facebook page to promote the story. And of course, after the fact, nobody was terribly interested in it. And a local civil rights law firm filing a lawsuit doesn't generate the kind of press to vindicate someone's name. And so it's incredibly meaningful when IJ comes in. And not only, as you say, did we have the resources to take this on appeal, to write what I think our local counsel referred to as monster briefs, because we have the time to actually a good appellate brief is 50, 60 pages of dense legal research, which, again, if you're on contingency and you're up in it, you're fighting qualified immunity, you're probably going to lose. People don't have the resources. So not only did we win it for Wayland, but we also have the resources through our communications team to put his side of the story out there. And ultimately, when that jury verdict was announced, he not only had the jury of his peers saying that he didn't do anything wrong, and that in fact the sheriff's office violated his constitutional rights, but he got media coverage both, at the time we got involved and then when the verdict came out saying, Wayland's not a terrorist. Wayland is the victim of constitutional violations. And I think that was just incredibly meaningful to him.
How has the sheriff's office reacted, right? Like, this all started because they were upset about, being the butt of a joke, and now they're the butt of a, massive campaign by IJ nationwide, right? And so are they kind of remorseful now? Are they more mad? What's going on there?
So I haven't spoken with them personally, but my hope is
just like Brad Pitt.
Yes, exactly. I know of them, but I do not know them personally. But my hope is that, that they, it may be embarrassing for them, but I hope that it's channeled into something positive. And that's sort of what the point of IJ's work in the immunity space is to clear the way for meritorious lawsuits like this to succeed. And part of it is getting vindication and compensation for the victims of constitutional violations, and that's very important. But equally, if not more important, is setting up good incentives for the government. So now the sheriff's office knows, if I go out and arrest somebody for some pretextual reason that's total BS, my office might face a $205,000 verdict. And in fact, the individual officer, he's going to be indemnified by the sheriff's office, but he has a judgment against him too. And even though he won't pay it, hopefully he'll have second thoughts the next time he thinks about doing something like this. And I hope that the sheriff's office going forward will say, we're going to have trainings to make sure that their officers respect constitutional rights. And hopefully their insurer will say, we don't want to be on the hook for this and pay the legal fees of both sides of this litigation. So we're going to make sure that you behave in the future as well. I think that a system that allows people to vindicate their rights just sets up good incentives for everybody.
So you are working on a case involving code enforcement. Ben mentioned code enforcement earlier, in Wisconsin, where that's being used in a retaliatory way.
Yeah, this is kind of a good example of the more typical retaliation case that you were talking about. And as Ben was saying, there's just so many offenses on the books that if you pick somebody, you can absolutely find something that they've done to get them for. And that's exactly what happened in Wisconsin. In Eagle, Wisconsin, our clients, Erica and Zach Mallory, have a property in a rural area, and they have a farm. They grow vegetables. They have some farm animals. In addition to their full-time work as a nurse and a cybersecurity technician. And Erica in particular, but Erica and Zach both, are really involved in the town politics. So Erica would go to town board meetings, and she'd get up and, say some things that were often critical of the town, like the way that they were conducting meetings and it wasn't transparent enough, or the way that the town was handling its finances or land use decisions, and things that impacted them as members of the community that they were really interested in. But often, they were kind of gadflies. They got up and said, this is a problem and I'm going to talk about it. And they also would, similar to Wayland, get on social media and talk about what the town was doing in Facebook groups and say, I think we should be doing this better, or talking about particular board members and things they thought they were doing improperly. And they soon found themselves the subject of a code enforcement action. And the town went to their property and said, okay, well, we've taken a look at, again, this very rural property where they are trying to conduct a small farm. And they said, we've noticed that you have an unpermitted flower box on your second floor of your house. We didn't get a permit to build that flower box. And an unpermitted farm stand where they just had a tiny farm stand where there was, kind of honor system, putting vegetables where people could, leave some money to pay for produce. And we've noticed that your grass is too long. And you had some construction materials out, because there's always projects on a farm. So even more so in rural areas, I feel like, for code enforcement, if you go onto any property, you can find a long list of things that are technically against the code because people are working on projects all the time, or throughout different seasons, you have different things that are going on your farm. So these offenses, most of them did actually exist, right? But it was very clear that the reason that the town was going after them and threatening them with almost $20,000 in fees for the code violations was because that they had spoken out at town meetings and because they were very vocal on Facebook. And in fact, one of the town board members at the time actually in an email to Erica said, I tried to help you out, but you really ticked off the board with your comments on Facebook and at town board meetings. And so the board voted with emotion when they voted to keep the process moving forward. So it's, I think, again, it just shows how pernicious and widespread this is, where something that's much more mundane, just talking about town politics and things that you're upset about and things that happen in every town across the country. And then you find yourself looking at tens of thousands of dollars in fines as a result.
One of the commonalities between these two cases is that in both cases, you're dealing with kind of smaller rural communities where everyone seems to know everyone else. And I've always wondered, in retaliation type cases, is that more common in smaller communities, perhaps because, local municipal governments, they know who their opponents are and they're happy to try to use the power of government to retaliate against folks? Or is it just because in those sorts of cases, retaliation is easier to prove because you have a smaller number of actors, and during discovery, you can find these sorts of emails. Although in this case, of course, they sent that email to an IJ attorney, which was not probably the smartest thing. But I'm just kind of curious, what is there a relationship between, smaller communities, tight-knit communities, and these sorts of retaliation cases?
That's such a great question. And I don't know what the data shows, like objectively, I don't know what the evidence would show, but my intuition, just based on talking to people and IJ cases, is that it's a little bit of both. One is that when you have a small town government, I think some people might be surprised, although if you've lived in a small town, maybe not, that like those petty tyrants in small town government bodies can sometimes be the most aggressive in violating people's rights. And I think there is a lot of interpersonal dynamics. You kind of know everybody, and there can be hostilities. But I wouldn't be surprised if it's some of the latter too, right? That this retaliation is happening in bigger cities. But and it's similar to what Ben was talking about, in Erica and Zach's case, it was easy for us to show, okay, you've brought all these violations against Erica and Zach that you haven't enforced against anybody else. And it's a small town, so we could kind of look at all of their enforcement history, right? And we could say, and also the way you did it was totally different than you did in everybody else's case. The town chairman was personally involved in assessing extra violations in their violation notice, aside from what the inspectors had observed. And that was all just way out of character. But in a small town, you can look at that whole body of evidence, right, and say, like, okay, well, this is the only one. Whereas in a bigger city, of course, you have a lot more to kind of sift through to say, okay, how out of the norm is this? How unusual is this enforcement action? And I think it would be, even in cases of genuine retaliation, it could be harder to show that this is unique, right? That this is, they are really targeting this person in a way that they didn't target other people.
So it sounds like it's really helpful then that, the local government pretty much admitted, the reason why we're doing this is because we're mad at you.
It's always nice when they send an email that said, hey, we did a retaliation.
Yeah, right, exactly. Does that happen pretty often? I mean, probably not as, nakedly as it was happening in Wisconsin, but, does the person who's having the enforcement, do they get some sort of communication from the city that says, this is because of X, or are they just kind of guessing that that's the reason?
Yeah, I think part of the problem is that often, towns aren't saying this. So I think it can be really hard to show, even if you could kind of guess just based on the timeline of how things unfold, that like this seems pretty clearly targeted at me. And one of the problems is it can be hard to get to the stage of litigation to discovery where you might get to see some of that communication between the officials who are acting and doing an enforcement. And that's where you would actually find that evidence typically, right? Typically, they're not telling somebody this is because of your speech, except in a situation like Ben's case where, the terrorism charge was because of the speech. But in these cases where they're enforcing other things that are unrelated to the speech because of the speech, I think typically it's harder to find that kind of direct evidence.
So where's the case now? What's going on now?
So in Eagle, the town board now is totally different than the town board at the time of the enforcement action. And we were actually able to work with the town board, the new town board, and they indicated to us that they wanted to reform their policies to make sure that things like this don't happen in the future and that the town is respectful of people's constitutional rights. And so we worked with them to totally rewrite their code enforcement policies to ensure that there's more protections and more transparency. And the way that we did that was kind of standardizing the process and saying, as I said, in Erica and Zach's case, there were a number of things that were different than how they typically enforce it. So making sure that the town is following the same procedure in every single case. And then also baking in some more protections for property owners, that they have ample opportunity to remedy any violations on their property once they've been pointed out to them before any fees even come into the picture. And that way, even if somehow they were able to institute an enforcement action that was retaliatory, nobody would face any fines unless they'd been given a full opportunity to actually just remedy the property violation. And so there were a number of reforms that the town board enacted as a part of a settlement with Erica and Zach, and they also, promised not to go forward with any civil enforcement action against them for the alleged code violations. So that case has now settled, and I think I'm very optimistic about Eagle going forward, that they've now enacted these reforms to ensure that doesn't happen to other people.
That's definitely, a great response by Eagle. But what also stood out to me is the fact that our clients wanted those broader reforms as part of their settlement package. You could see other folks in that same situation accepting a settlement that says, my property's fine, but I don't have to care about everyone else's. But it sounds like the Mallorys really wanted to make sure that the town of Eagle changed what they were doing.
Yeah, absolutely. From the very beginning, Erica and Zach are classic IJ clients, and that the reason that they were involved in the case, the reason they wanted to bring the case is for the broader principle, right? To ensure that Eagle knows, the First Amendment matters and that people have a right to speak out about their government. And so they were always, from the start of the case, interested in, in advocating for that right and making a broader impact than just their own case. And I think Erica told a great story to us when we were, talking about her interest in the case, and she's an operating room nurse. And she said, one of the things that I have to do is, even though I'm the nurse, I'm not the surgeon, is if I see the surgeon doing something in the operating room that I haven't seen before that I think is off, I have to say, wait, everybody stop. Can you explain what you're doing? And I am looking out for the patient here, where I have to be able to advocate even in situations where it's uncomfortable for me to do so. And I think that's the mentality that led her to be so vocal at town board meetings as well, and to say, hey, why are you doing this? The town deserves to know. And having that attitude of just, I'm here for the principle and I'm not afraid to speak up. It definitely was a credit to her and Zach as IJ clients as well.
Yeah, it takes a lot of courage to stand, especially in a small town. Everyone knows each other, and, it kind of puts a spotlight on people in a way that can be uncomfortable.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost-efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
We've had an IJ client who had, consequences for being part of an IJ lawsuit. So, maybe talk about that a little bit.
Yeah. So this is our client, Robert Reeves, who we first got involved with Robert as a client in our Detroit forfeiture lawsuits. That's a class action against Wayne County for Detroit's vehicle forfeiture program, which is unconstitutional. And we had a big win in the Sixth Circuit recently, in which the Sixth Circuit said Wayne County was violating the constitutional right to a prompt post-seizure hearing after the county takes your car for civil forfeiture. And Robert had lost his car to civil forfeiture and was one of our named plaintiffs in that lawsuit, challenging the constitutionality of the system. The day after we filed that complaint, the day after Robert became a plaintiff in a civil rights lawsuit as an IJ client, the prosecutor in Wayne County sent a message to the officers who had been investigating a string of retail thefts over the summer that Robert's car was seized in connection with, allegedly, and said, "Hey, can you look into this again, and can you renew your warrant request for his arrest?" And they then, I think 4 days after, a week after, Robert found himself facing criminal charges in connection with the string of crimes that they had alleged they had taken his car as a part of. Interestingly, that alleged criminal activity was alleged thefts from Home Depot of rental equipment, so like heavy construction rental equipment that was never returned and then sold to other people. This was a multi-month investigation by Wayne County Prosecutor's Office. It involves private investigators from Home Depot. It involved helicopter surveillance. It was a huge project. And there were a number of people that were listed in the notes of that investigation. None of them faced any charges at all until after we filed our class action lawsuit. And then only 2 people found themselves facing criminal charges. And that was Robert and one other who was alleged to have been the ringleader of this whole operation. We, working with local counsel and criminal counsel in Detroit, we got those criminal charges dismissed against Robert. Wayne County then filed those charges a second time. And this time there was even less pretense. They only filed them against Robert. So they have this multi-month investigation that they say people have stolen these huge pieces of rental equipment from Home Depot, and they've taken off the GPS units and sold them. And the only one who's facing criminal charges is Robert, who they allege had received stolen property. And that's not a coincidence, right? It's because Robert was the only one in the investigation notes who was a plaintiff in a federal civil rights lawsuit challenging this practice. And so we then filed another lawsuit on Robert's behalf, suing Wayne County, the prosecutor, and Wayne County generally, and the corporate counsel for retaliating against Robert with these baseless prosecutions.
You know, one of the most fascinating things about this retaliation case in particular is that one of the defendants is, in fact, the attorney who is representing Wayne County in the underlying forfeiture action. So you're right now living the dream, I think, of every attorney of suing their opposing counsel. And I'm curious, what is that like in a retaliation case? How does that affect your ability to litigate it? And how does it affect just the ability to bring these sorts of cases?
I think it made for a fairly interesting oral argument in the Sixth Circuit when you're sitting at a table next to somebody who you're personally suing in another lawsuit. Wayne County has since the Sixth Circuit decision actually has just hired a new law firm to represent them. So we are no longer both suing and litigating against Wayne County's corporate counsel, but for a long time we were. And I think I like you said, the reason you say it's an IJ lawyer's dream is because so often we find with government counsel that they just act in ways that are really unbecoming of someone who's representing the government and somebody who is representing the authority of the state. And this was certainly the case here. And so I think it's really validating both to us and to Robert to say, no, you can't behave this way. And actually one of the reasons for the retaliation, which was very obvious, I think, is that one, to just send a message and to kind of target Robert for what he did, but also because it was gamesmanship, right? They were using this in the federal lawsuit, and they said, okay, well, actually, you know what, Judge? We have this state criminal prosecution that's pending, and so you can't consider Robert's claims at all because of abstention doctrines, and that, you know, you have to let this play out in the state criminal proceedings, and Robert can't even bring these claims in federal court in the civil rights lawsuit. And so I think that just adds another layer to it, right? That it's this really unseemly gamesmanship of we're doing this in order to win an advantage on you in the other lawsuit.
I mean, it's clear to us, right, that the prosecutors were doing this to Robert in retaliation for being part of this other suit. But how do you convince a judge of that?
Yeah, so we're litigating this right now, actually. We're up in the Michigan Court of Appeals on interlocutory appeal. So some of our arguments have been, the trial court accepted some of our arguments and rejected others. And we're kind of fighting this interlocutory appeal battle before we go back down and continue litigating the case. And one of the hurdles is that Wayne County will say, they had probable cause to seek a arrest warrant, and the warrant was issued. And so that's it. You can't pursue a retaliatory prosecution claim where there's probable cause. And this is something that Ben was alluding to earlier. And what we're arguing is that there wasn't probable cause, actually, because everybody who was involved knew the reason they were seeking the warrant wasn't because they thought Robert did this. It was because of what was going on. And we alleged in the complaint that there was, that the prosecutor was directed to do this by the corporate counsel. And the way that they responded to that is they said, well, he was just giving legal advice to his client. The corporate counsel was giving legal advice to his client, the Wayne County prosecutor. So they don't even deny that that's what happened, that he was directing him to do this. So they just say this was legal advice that he was giving him. And of course, he's able to give him legal advice. That's part of their qualified immunity argument, that how would he not know that he's not able to give his client legal advice? There's no cases saying you can't do that, which is obviously very, misunderstood way of describing what was happening. But all that to say, one of the hurdles is for us is, like I said before, going to be able to get to the discovery phase, right, where we can actually find the communications and talk to the witnesses and depositions to get an understanding of exactly how this went down. Because the evidence we have now is really the timing of this, that it was the day after we filed this lawsuit that all of a sudden you've shown interest in prosecuting our client, but also that this is part of a broader practice of retaliation in Wayne County. Because Robert was not the only one of our clients in the federal lawsuit who found himself being retaliated against. When we filed the federal lawsuit, Wayne County also showed kind of renewed interest in the forfeiture proceeding against the car of one of our other clients. And we litigated that case up to the Michigan Supreme Court. And when they lost in the trial court on that case, the judge said, listen, I just don't understand what's going on here, to the prosecutor's office. He said, I know you have a job to do, but it seems to me like you have bigger fish to fry than going after this woman who's just trying to get her son to school and buy groceries for her family. Like, what's going on here? This car is not worth anything. And in response, the prosecutor who was representing Wayne County said, well, Your Honor, there is also this federal case. And she kind of stopped there, but it was an admission, right, that this is connected. And so that's the other aspect of evidence that we're trying to bring to bear to the court, is that it's not just Robert. The county is doing this repeatedly, even in this lawsuit, against multiple people, that they are looking for ways to retaliate against people who dare to speak out about what the government is doing wrong.
So we have, and I know that this case isn't, either of yours, but wondering if you can touch on it kind of briefly. We have our kind of most recently launched case in Virginia, where our clients were trying to do some food truck reforms with the city, and one of the local, council members got really upset about that. Do either of you want to talk about that?
So this is a case on the eastern shore of Virginia, which, if you know mid-Atlantic geography, it's the Delmarva Peninsula, the parts on the other side of the Chesapeake Bay from where IJ is. And these two people who are originally from Haiti, but one is a citizen, one is a green card holder now, married couple, were starting a food truck business that catered to the Haitian community out there. And so far as they knew, that was totally legal. The town gave them a business license to operate the food truck. But one of the council members, as you pointed out, who owns a restaurant, didn't like the competition that he was facing. And so he sort of deputized himself to be a personal terror to this couple, to the point of personally unhooking their water connection. When they called the police rightly said, no, you're not allowed to do that. You're just a council member. But even so, he did that. And then and then he successfully persuaded the town to pass this total ban on food trucks except for special events. And so that was a very classic IJ case, defending the economic liberty of people to, to make an honest living and not to be subject to these protectionist laws that are obviously just trying to protect incumbent businesses. And so at the behest of these two people, IJ wrote a letter to the town explaining, our sort of standard theories on why these food truck bans are unconstitutional and asking the town to repeal it. And in response, the town went hammer and tongs against, these two food truck operators. And so they had already been given a business permit. The town had said publicly, both in public meetings and to local media, that they'd be able to operate for the full year of their business permit before this food truck law went into effect. But the town said, no, we're not going to honor that anymore after they got this letter. And also said, we're going to try to retroactively impose all of these fees against you by retroactively reinterpreting our zoning ordinances from before we even passed the food truck ban to say that they actually banned your food truck business, even though we had given you a business permit to operate a food truck. And so, again, it's another situation where the timing was, we sent a letter. The next day, they send a letter to our clients informing them that they're going to do all of these horrible things to them. And so they were at the time just people we were talking to, potential clients. They are now clients, and they're suing both over the unconstitutionality of this zoning and food truck ban regime and also about the retaliation that they faced. And so, again, it's another situation where small town, limited number of people, and where an official, here a council member, can wield his authority pretextually to go after people who he doesn't like. In this case, both who he doesn't like politically and people who he doesn't like competing with his business. And I think the one caveat, you might get the impression from our last two anecdotes that the government is constantly retaliating against our clients, and that is not true. It is still relatively rare for the government to do that, hopefully in part because they have some, goodwill, but also just once you know that IJ is involved, the worst thing that you can do is retaliate against our clients, because then we will come after you for that. So it's still quite rare. So if anybody out there has a great case for IJ that you want to bring to us, it is very unlikely that the government will retaliate against you, especially because we're now building this body of law showing that the government can't do that. But if it does happen, IJ will be behind those people 100%.
Yeah, we've filed 418 cases, and it's happened in, 1.5, I guess, cases. So
I know. And that's one of the reasons that we were so energized to take on Robert's case, right? Is because this just isn't done. And we, it is much for Robert as IJ saying, listen, we got to send a message that when we are involved in a case and representing our clients, that this is off limits. This is beyond the pale.
Thanks for watching today's episode. We had a lot of comments and questions from our last episode about our new report on qualified immunity. So let's start with some of those comments. At EB4506 writes, qualified immunity is a throwback to nobility. Belong to the right group and you're immune. So true. And in fact, many courts today trace the doctrine of immunity to the old saying, the king can do no wrong. At Marantine writes, if ignorance is not an excuse for the accused, then it's not for the government. They should be held to a higher standard because they have a duty to protect constitutional rights. Absolutely. At Raya writes, thank you, IJ, for your hard work in compiling the unaccountable study. What a colossal undertaking. And it was, and I have to give a huge shout out to our phenomenally talented colleagues in strategic research who made that report possible. At Larry Bolus 1049 writes, how does IJ not have 250 million subscribers? Keep up the great work. Well, thank you, and hopefully we'll hit 250 million subscribers someday soon. Now let's move on to the questions. At Clarity Determination writes, does the defendant have a free lawyer as well? Well, in fact, yes. Government officials who are defendants in qualified immunity cases are typically represented either by government attorneys or by attorneys hired by union representatives. In either case, the government official isn't paying for his own attorney. And as UCLA law professor Joanna Schwartz points out, not only do these officials receive free legal representation, but also a stunning number of them, over 99.5%, according to her study, which was published in the NYU Law Review, are fully indemnified for their conduct. Meaning that even if a person can defeat qualified immunity, the government official responsible for the violation doesn't pay a cent. At Fata Morgan Expressio writes, I don't understand why the previous court position of granting cops a good faith predisposition was wrong or inadequate. Well, from a legal standpoint, the good faith approach to immunity runs into a couple of problems. First, in the context of suits against state officials, which are brought under a federal statute called 42 U.S.C. Section 1983, nothing in the text of the statute reflects Congress's intent to protect officials who violate people's constitutional rights in good faith. Second, because good faith immunity hinges on the government official's subjective state of mind, it wasn't a particularly workable legal standard in practice. But even assuming that it was workable and had some legitimate basis in law, calls for good faith immunity largely miss the point. The Constitution protects our rights regardless of whether government officials are operating in good faith, bad faith, or something in between. And the person whose rights have been violated is still harmed even when the government official is acting in good faith. As Chief Justice Marshall famously observed over 2 centuries ago, where there is a legal right, there is also a legal remedy. And no form of immunity should stand between a person and their rights. At Robert Kelleher 1850 asks, if there's not case law saying that what they did was unconstitutional, well, then they get immunity. And if they get immunity, how can there ever be case law on those facts? Well, you hit the nail right on the head with this question. That's precisely the problem that's been playing out now for decades in circuit courts across the country. Because judges can dismiss cases on qualified immunity grounds without first deciding whether the Constitution was actually violated, it is common for clearly established law not to develop, despite litigants bringing a steady stream of civil rights challenges. For a brief time in the 2000s, the Supreme Court, recognizing this problem, required lower courts to decide the constitutional question first before moving on to address whether the right was clearly established. But in 2009, the court decided a case called Pearson versus Callahan, where they reversed course and held that a court retains discretion to decide these issues in any order it likes. So, the problem persists and government defendants continue to benefit. That's it for today. Thanks again for watching, and don't forget to subscribe.